Hi everyone, Miss Gok here, and I am so excited for this interview that you're about to watch right now. I am about to interview my beloved fiance, Mr. Ben Anderson. Um, he is currently a law student at Syracuse University. So I thought, who better to be talking to about all of this trial stuff than my fiance? So I'm going to ask him a couple questions, but first, Ben, if you could, would you mind doing just a little introduction for everyone?
Yeah, absolutely. Hi, everyone. My name is Ben Anderson. As Ms. Cox said, I am a law student over at Syracuse University, and I am in my third and final year over there. I've gotten to take lots of exciting courses. I've taken courses in criminal law. I've taken courses in civil law. I've taken courses in different types of law, employment, disability, and all sorts of things. Um, and I'm also currently working for Syracuse City School District. I work in the Office of Human Resources.
So I'm going to ask him a couple questions, and hopefully you guys are ready to take some notes. We're going to use these notes to help us as we move forward in Monster, understanding a lot of the different terms that are associated with a trial, but also to help us remember like how a trial works. And I'm sure he's about to teach me a lot of these things too. So make sure you have your Cornell notes out, write down your essential question, and take some notes. Okay, here we go. Ben, first question is first and foremost, there are two types of lawyers that we meet in this text. One is called a prosecutor, and the other is called a defense attorney. What is the job of each of those lawyers?
Sure. Well, first, it's important to understand that the case that the book talks about is a criminal case. And that's what happens in a criminal case is a defendant or an individual breaks state law. And so that's where the role of the prosecutor comes in. The prosecutor represents that state, or represents the people of that state. And it goes through, as the case proceeds, it presents evidence, it calls witnesses, and it tries to demonstrate that this person, this defendant, did violate state law, and because of that, they should be punished. Now, the role of the defense attorney in relation to the prosecutor is to push back against the case that the prosecuting attorney is attempting to make. They can poke holes in the prosecutor's case. They can make their own case. They can establish their own witnesses, and they demonstrate that the defendant, or the person being charged, is not guilty of the offense that the prosecutor is trying to say that they are guilty of.
Okay, so if we were putting this in terms that I feel like I could understand, the prosecutor is more like the offense where they're trying to show that this person is guilty, and the defense attorney is like defense where they're
It's
trying to
defense.
keep that from happening.
That's exactly.
Okay, awesome. So you just described the difference between a defense attorney and a prosecutor, which is important because now I understand like they're both lawyers, but they have different jobs. My question is, so the crime that they talk about in the book Monster took place on December 23rd. However, the trial didn't start until like July 7th. And Steve had to spend all of this time in prison while he waited for it. And I guess one thing I've always wondered is why is there so long between a trial? Like in my head, the trial happens right after because I guess I've only seen it in movies and stuff. So it does happen right after the crime. But when they explained that, I got a little confused. So why is there so much time in between the crime and then the actual trial?
Sure. Well, that's because there's a lot of procedure, and there's a lot of there's a lot of things that both attorneys need to do before a case eventually goes to trial. There's a lot of I think the thing that takes up the most amount of time is something called discovery, where each attorney will they'll go out and they will conduct investigative reports. They may talk to experts. They may, depending on the case, they may talk to like the law enforcement or the police. They would consult with expert witnesses, things like that, and that process can take a very, very long time. But there's a lot of details. There's a lot of work. There's a lot of writing. There's a lot of fact finding that these attorneys do behind the scenes, and it's not always something that a defendant or a client might engage with or be a part of. A lot of what happens, a lot of the jobs, or a lot of the work that these attorneys do, Steve Harmon is not a part of, which is interesting because this case is about him.
Yeah.
Right?
Like, shouldn't he be a part of coming up with those facts and doing all those things?
You would certainly think so, right? He's very invested in this case.
Yeah, like they talk about like his life being on the line, whether he's spending a life in prison or they mention the death penalty or whatever the verdict might be. I mean, his life is on the line here.
Yes, that's exactly right. And this gets to an issue about accessibility to the law.
Wait,
right?
What does accessibility mean?
The ability to understand the law, to work with the law, to read the law, to be able to interpret the law, to understand how the law applies to us. Right? We are told that the law applies to everybody, all U.S. citizens equally.
Right.
But that doesn't mean that we all understand the law equally. Some of us go to law school just to understand the law, and even then, it can be a little bit questionable.
Right? I guess now I'm thinking about like how many laws do I actually know? And I guess my thought is I know that I'm not supposed to kill people and I'm not supposed to steal things. Other than that, like I don't know if I know that many laws.
Yeah, and so there's a bit of a gap. Well, it's admittedly a very large gap, right, between those who understand, those attorneys who spend their lives in court and they work on these cases every day and they make this their career and they understand the law, and then those who do not.
Man, I guess I never really considered that about the laws of our states and countries. Huh. Okay, so here's a question. The attorneys are the ones who are trying to prove the person is guilty or innocent. But then after they do all of that work, who decides if they are guilty or innocent?
Sure. It's the job of the court, really. Well, it's the court and then a jury.
Okay.
Right? It's the court's role, the judge's role, is to facilitate the case as it proceeds, and to understand the applicable law to the case that's being presented, and then present that to the jury, who then makes their determination whether the defendant is guilty or not guilty. And that's based on their understanding of the law that they've received from the judge, all of the facts that have been presented over the course of the case. Right, they're sitting in that. They sit in the box when the attorneys go up and they examine witnesses and they ask them questions. They present evidence. The jury sees all that, and then they make their decision based on that and their understanding.
Okay, so the judge is kind of like the person in charge of this whole process, but
yes.
The juries are the ones who watch as the lawyers go back and forth between guilty, not guilty. They call people to the stand. They do all the interviews and everything. And then the juries are the ones who make that decision.
Yes.
Does it have to be unanimous or is it majority? Or is
it does actually, it has to be a unanimous verdict.
Oh, okay. So if people don't agree with each other, do they go back into the court and listen to more? Do they talk it out amongst each other? Like, how does that work?
There's a few different things that could happen. Generally, they'll continue to deliberate until they reach a unanimous verdict. That being said, I guess I'm not sure the amount of times that a jury is not in the event that a jury is not able to reach a conclusion. I think that's what is referred to as a hung jury.
Okay. Oh yeah, I've heard that before.
Usually, yeah, I think usually what happens is there's they'll do a new trial with a new jury.
Okay, interesting. And then one more question about the jury. How are they chosen? Because they're just like people, right?
Yeah, that's right. The whole point of a jury, right, is you want a neutral person to a neutral party who will consider the facts without a personal bias.
Hmm.
So how jury summons work, right, is usually there's summons sent out to about 50 or 60 people in a given area, and from that group, it's whittled down to usually 14, and they do that through a series of questioning. They'll usually ask very general questions to these people regarding like their opinions of the law, whether they're related or know anybody in like law enforcement, things that would generally indicate whether that person would have a bias or not. And then through that process, this group of 50 to 60 some individuals is whittled down to about 12 to 14, and that's what's called a petty jury. They sit in the box. They're in the courtroom hearing the case.
Okay, so these people, you have to make sure that they have no biases, right? So they can't like know anyone in the trial, or they can't have like a job that might be connected or something like that. And then from that group of people, they choose who's going to do it. But it is also kind like there's part of it is totally random, and part of it is they're trying to make sure that of those random people, there are no biases.
Exactly. And even beyond that, both the prosecutor and the defense attorney have some power in selecting the jury as well.
Really?
Yes.
Okay.
Yep, they do. They have the ability to strike jurors. They have the ability to take someone off the jury if they think that they have a bias or will not be impartial.
Oh, so they don't ask people to join, but they can get rid of people if they think like they passed the bias test, but I see that they actually do have a bias.
Exactly.
They probably don't say it like that because I don't know what that voice was, but yeah, okay. That's the jury. Um, One question that I have always wondered, because I watch these TV shows and I see these movies, and even in the book, I see the really big scenes where they say, I object, or objection, right? So, what are the things that, like, during a trial lawyers are allowed to do, and what kinds of things are they not allowed to do?
Sure. So over the course of a trial, what the attorneys are doing is they're submitting evidence. And they can do that through examining witnesses, right? And witnesses will then testify. Their statements will be on a record that can be referred to. Their statements are memorialized. Go back and say it time. And so attorneys will examine witnesses to introduce evidence. They also might introduce like physical evidence. And so objections come when an attorney improperly or doesn't go about the correct method of getting that evidence before the court.
So it's like a flag on the play.
Exactly. Yeah, exactly. And then another attorney will call out and state the basis for their objection. The objections that are referenced or that are brought up in the book all relate to witness testimony.
Yeah. So, like, one example is leading. What does leading mean?
Sure. Well, on direct when you examine a witness or when you ask a witness questions, in the manner that this attorney is doing, you generally want them to tell the story. You want their testimony to be moving the narrative forward.
Okay.
Right. So when an attorney is kind of guiding a witness towards answering questions in a very specific way, that's a leading question. You shouldn't be doing that.
Oh, okay. So to recap here, you want the witness to tell the story from like their perspective, their point of view, because like that's what's honest and like that's what they experienced. But if it's the lawyer, for example, putting the words in their mouth and they're just agreeing or disagreeing to it, it's no longer the witness who you called telling the story, it's the lawyer telling the story.
That's exactly right. And if you're an attorney, if you're a prosecutor trying to make this case to show that a defendant is guilty, if you are, if you call this witness who will tell this story and explain that this person is guilty, you as an attorney would take away from that by just guiding them towards questions. You want as a prosecutor, you would want the defendant's guilt to just kind of come out through the story that the witness tells.
Okay. So on top of all the work that the lawyers are doing before the trial, they're also the ones who are talking to the witnesses. And those are witnesses that they bring to the trial. And there are just certain ways that they can handle those witnesses that are okay, and certain ways that kind of feel like cheating or like not doing it correctly.
Yes. And there are rules, right, that all attorneys are expected to follow with regard to entering evidence. And so when an attorney objects, they're stating that this attorney has violated those rules. They've done something improper.
Okay, that makes sense. My final question for you here is, there are a few words that I really like to know the meaning of. I think I kind of have an idea based on context clues, but I thought you'd probably be able to explain it the best way. So the first word that I'd like to know the meaning of is stenographer. I've heard of this before. What is a stenographer?
So a stenographer is a person. It's their job to write down everything that is said in any court proceeding, really. Anytime there's a need to establish what's called a record, it is just a complete transcript of everything that is said. So during a trial, a stenographer will often sit in the corner. You'll see them with like a little keyboard. It looks almost like a typewriter. They are writing down every single word that is said by the judge, by the attorneys, by the witnesses, a complete record of everything that happens.
What is a testimony?
Testimony is just a statement or whatever a person says during a court proceeding. If a witness is called to give testimony, they come up to give statements that explain either their side of the story or their perspective of what happened or what they saw. That's all testimony.
Okay.
Statements that a person makes.
Oh, okay. And then a ruling.
A ruling is how a court decides on an issue.
So it's like the final result.
Yeah.
Cool. Thank you so much for doing this interview with us. I know you're super busy, but it was really nice to be able to talk to you about this stuff, and it definitely helped my understanding about what goes into a trial.
Of course. I'm glad I could help.